The changing times. Fate highlights the injustice in the Sandy Creek disaster. Laws in the state of Florida in 1977 allowed a sitting judge to override a jury's recommendation in the sentencing phase of the trial. In the case of David Monroe Goodwin, the sitting judge, James C. Adkins, Jr., considered the jury's recommendation for mercy, which meant life imprisonment, to only be advisory, and took it upon himself to override the jury and order the death penalty. The judge stated, "The evidence, beyond every reasonable doubt, shows that the defendant was engaged in the kidnapping of 3 persons, that he participated in the binding and gagging of the victims so as to make them helpless, and he knew they were to be slaughtered." This former Florida Supreme Court judge never once heard the above words uttered in testimony during the trial. A thorough search of the court transcripts revealed no such testimony. Former Florida Supreme Court Chief Justice James C. Adkins, Jr. has been accused of bias against the defendant and throwing the trial to the prosecutor. This judge also appears to be dishonorable in attempting to support his wrongful override. Now, 39 years later, the state of Florida has abolished the jury override. Governor Scott signed into law on March 7, 2016, the legislation that abolished the jury override. If this had been the law in 1977, David Monroe Goodwin would never have been sentenced to death, would never have spent close to 4 years on death row, would probably have been paroled years ago, and would now be spending a normal life with his family. David Monroe Goodwin remains incarcerated. We should demand his release at the earliest moment. The Commission on Offender Review must be aware of this. Possibly they will take immediate action to correct this egregious, premeditated injustice.